Well, thanks everyone for coming. We're going to start with employment law updates affecting the workplace. Some quick intros. I'm a senior associate in the employment group. My name is Jamie Talt.
I'm Ryan Wessels, also a senior associate in the employment group.
I'm Kevin Jones, and surprise, I'm also a senior associate with Corella.
Unmute your mic, please.
Okay, so I am going to kick things off talking about the Pregnant Workers Fairness Act. This is a relatively new law. Congress passed it in 2023, but the EEOC last summer issued its regulations and guidance on the law. So I'll start off with a little bit of background. As you probably know, there's already the Americans with Disabilities Act and California's Fair Employment and Housing Act that require employers to provide accommodations and leave to workers disabled by pregnancy. But the PWFA, as I'm going to call it, has requirements that are more stringent than those laws. So we're going to go over those today. So the PWFA requires accommodation of any known limitation related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. And so this can include conditions that exist before, after, and during pregnancy. And these are things like, other than just pregnancy, lactation, fertility treatments, postpartum depression. And the key thing here is this definition of limitation is much broader than the definition of disability under the ADA and FEHA. And the EEOC has explained in its regulations interpreting the law that this can include minor and episodic problems, such as, if someone's experiencing pain while standing, needing time off for appointments, and needing schedule modifications due to fatigue. So turning next to accommodations, this is a big change. The PWFA deviates from the ADA and FEHA and actually requires accommodations even if the employee can't perform the essential functions of their role, as long as that inability is temporary and could be reasonably accommodated. There is still a caveat, though, that if that accommodation would cause an undue hardship, then the employer does not have to excuse the performance of the essential functions. And the EEOC regulations provide some factors to consider in evaluating that undue hardship analysis. For example, the length of time that the essential functions would be waived. The regulations also provide some examples of pregnancy-related accommodations that are expressly deemed reasonable in most circumstances. So these are things like having water at a workstation, having additional breaks, having seating for employees that otherwise stand. And again, while employers can still deny these accommodations, if they would constitute an undue hardship, the employer would have to, have very strong justification for that, because the EEOC has already said, in most circumstances, these are going to be reasonable. In terms of documentation, so the regulations only allow employers to request medical documentation if it's reasonable to do so in the circumstances. And this is because it can be difficult for pregnant workers to get appointments, early on in pregnancy or on short notice. The regulations state that it is not reasonable to require documentation when both the limitation and the need for accommodation is obvious. So some examples are if a pregnant employee needs a different, uniform size or safety gear, things like lactation accommodations, that's not going to require supporting documentation. And then also the accommodations we just looked at that are, expressly deemed reasonable in most circumstances are not going to require documentation. On the other hand, things like lifting restrictions, where the employer really needs to know for safety, what is the exact limitation that, is most likely to be reasonable to go ahead and get that documentation. So kind of some takeaways for the PWFA in light of these changes to prior law. Make sure to update pregnancy accommodation and leave policies, provide training to managers in HR and anyone who is responding to and handling accommodation requests about these new requirements, and probably take a look at these accommodations that are deemed expressly, reasonable, and see if there would be an undue hardship. If not, make that decision. And so if a pregnant employee comes to you with that request, you can quickly just go ahead and process it. So switching topics slightly and talking about insurance plans and infertility. So last year, Governor Newsom signed Senate Bill 729, which requires large group health insurance plans to provide coverage for fertility services, including IVF. So with that, California joins 14 other states that mandate insurance coverage for IVF. Small group. Okay. I think it's it's working now. So small group health plans will be required to offer coverage for the diagnosis and treatment of infertility. The bill also expands the definition of infertility to include an inability to reproduce either as an individual or with a partner without medical intervention, which would include same-sex couples and unpartnered or single people. So I think a key takeaway for this is any employer with a fully insured health plan, that covers California employees should consider confirming with their health insurance insurers that they're ready to comply with these new requirements. And if the employer already offers fertility benefits through a separate vendor, checking that, those benefits aren't now redundant. And we're gonna start talking about social media now. And I'm going to kick this off with a little poll. So for the people in the room, feel free to raise your hand in response. And for the people online, drop it in the chat, like yes or no. And the question is, if you've had to deal with or address an employee's offsite social media use in the workplace. Yeah, we've got some yeses. Yep. And yeah, I think we're going to see more and more of that. Especially with this younger generation who grew up using social media entering the workforce. It's just an issue that's, just coming up more and more frequently. And there's a recent Ninth Circuit decision that provides some good guidance and good reminder about best practices in investigating and responding to employee complaints about off-duty social media use. So the case is Okanowski versus Garland. Quick overview of the facts. Okanowski is a female staff psychologist in a federal prison. She discovers an Instagram account in which a male colleague has posted hundreds of offensive memes and posts on the basis of sex, and some of those posts specifically target Okanowski. She complains, and although the prison eventually, determines that male colleague had violated the anti-harassment policy and had sent a cease and desist letter, the Ninth Circuit still held that a jury, could have found that the prison had violated Title VII. So in the interest of time, I'm going to skip through a little bit and kind of focus on remedial measures. This case really highlights the need for employers to take quick action in investigating and responding to employee complaints of this nature. So here, the prison took some steps to address Okanowski's concerns, but on the other hand, several supervisors just failed to respond at all to her complaints. The special agent who was assigned to investigate took 3 weeks to start doing anything on the case. And during that delay, the frequency and the intensity of the posts really escalated. So the Ninth Circuit found that, again, a jury could find that the prison's response was not prompt or effective. The Ninth Circuit also found that the investigator should have reviewed all of the posts that sort of endorsed or made light of violence against women, not just ones specifically targeted at the complainant. I think a word of caution here, though, is, while investigators should be taking kind of a totality of the circumstances, broader look when it comes to social media posts and accounts, it's also worth just being very careful that the investigation is not muddling things that violate the harassment policy from protected conduct that might otherwise be in some of the other posts. So, whether it's religious affiliation, political discussion, referring to the terms of someone's employment, really carving out in an investigation what is violating policy, despite having looked at the full breadth of posts. And finally, the Ninth Circuit also found that evidence of other colleagues engaging with the offensive conduct or the offensive social media content is relevant to, a hostile work environment analysis. So any investigation should also examine whether these other employees were, following, liking, commenting on, offensive accounts and posts. So that's the takeaway from Okanowski, and I'm going to hand it over to Ryan.
Thanks, Jamie. I'm going to start with AB 2499, which is the amendments to the crime victims leave laws. And I think it's one of the new statutes that's going to cause employers the most headaches. It took an already complicated statute and made it even more complicated by adding exceptions and nuances to the statute. So if there's one takeaway from the discussion on AB 2499, it's that if you become aware that an employee is a victim of a crime, and we'll talk about that what that means in a second, slow down, consult with a trusted resource or legal advisor before taking any irreversible action. So what AB 2499 did is it expanded employee protections in 4 ways. First, it expands the types of crimes that are covered by the statute. Second, it expands the reasons that employee victims can be absent from work without repercussion, what we call a protected absence. Third, it moves the statutory framework to the FEHA, which allows for the California Civil Rights Division to enforce it and also imposes accommodation obligations on the employer. And fourth, it includes a new notice provision. Of these expansions, I think the first one is probably the most important one. I put crimes in quotes because it's actually irrelevant whether anyone was convicted of, arrested for, or prosecuted for a crime. What the statute does is it revises the definition of victim to include not only a victim of sexual assault, domestic violence, or stalking, which was in the old framework, but also any time where a victim incurs bodily injury from another, threats of violence, or is involved in an altercation using a firearm, whether or not the firearm went off. So as you can tell, that's a much broader list of conduct that gives rise to the obligations under the crime victims leave laws. So what obligations does AB 299 impose on employers? First, it protects certain absences. Jury duty, court duty, nothing's changed. It also protects absences for victims to obtain court relief, for employees who are victims to obtain court relief if for themselves or a child. Usually that's some sort of restraining order. For employers with 25 or more employees, it also protects other absences. First, protects absences when employees seek relief relating to their victim status other than court relief. So the statute lists a bunch of types of relief that's protected. This might include things like relocation services, caring for a family member, medical treatment, victim services, the like. Secondly, it also protects absences for employees whose family members are victims of crimes. And everyone here might remember that a few years ago, we got this new law that added this designated person requirement in California, which allows employees to designate a non-blood relationship as a person for which they can use certain leaves, including this crime victims leave. Employees do have to give notice when feasible. Employer can ask for documentation, but importantly, the statute explicitly states that an employee's signed statement saying that their leave is for a purpose under the statute is sufficient. So you can't require a medical note, court order, police report. A signed employee statement is sufficient. And the employer has to keep any request or documentation they receive confidential. An employer can limit the leave under this policy to 12 weeks if the employee is the victim, and usually 10 days when the employee's family member is the victim, but there are a lot of nuances and exceptions to that amount. AB 2499 also imposes accommodation obligations on the employer. We're familiar with this from the disability context, and it's a very similar analysis. The employer has to engage in the interactive process, provide an accommodation unless there would be an undue hardship. So types of accommodations for crime victims might include things like changing work schedules, implementing safety measures, allowing them to use a cell phone while at work, changing the work location, things of that nature. Employees are also allowed to use any accrued leave, sick leave, and vacation for crime victims leave. And employers are not allowed to discriminate or retaliate against an employee either for their status as a victim or for requesting any accommodation. So what should employers do? The most important thing is to train your managers and human resources on this new statute. They don't need to know the ins and the outs. It's a complicated statute, but they need to know that if an employee tells them they're the victim or a family member is a victim of a crime, alarm bells need to go off. They need to slow down and consult resources. Because in addition to what I just shared, there's also a new notice provision by the statute. So as of effective July 1st, the government's going to provide a model notice. Once it does so, employers will have to give that notice upon hire, annually, upon employee request, and anytime an employee discloses that they were a victim. So it's not enough just not to do anything, but you have to have an affirmative step of giving them notice. And lastly, employers might want to update their handbooks with this policy, including probably also their accommodations policy. One area that the legislature was somewhat active in was strengthening anti-discrimination laws, although none of the changes were groundbreaking. Before AB 15, certain code sections defined race as inclusive of traits historically associated with race. The legislature thought that was confusing, ambiguous, struck the word historically from the language. So employers should update their discrimination and harassment policies to remove that same term. And if applicable, they might want to review any dress and grooming policies to see if there's anything that implicates a protective hairstyle. SB 1137 prohibits discrimination based on a combination of protected traits. This is what we refer to as intersectionality. And the legislature gave an example, which they said Black women, for example, are often treated differently than both white women and Black men. And it was the combination of those traits that could cause a disparate impact or discrimination. So I've included some language within this slide that we propose adding to any sort of anti-discrimination policy to account for intersectionality. SB 1100 is the new statute that makes it unlawful to require a driver's license in job application materials. The rationale for this policy was the legislature thought there was a disparate impact for people in low-income communities, people in urban areas who relied on public transportation, and people with disabilities who might not have driver's license. There's one big exception to this one, which is if the employer reasonably expects that one, the job duties will require driving, and two, other forms of transportation would not be comparable in time and cost to the employer, they can still include the driver's license requirement in their application materials. But everyone should check their job postings and other application materials, make sure that if you require a driver's license, it complies, and also train any HR and recruiting staff.
Are we taking questions or can I ask a question?
Go for it.
What was that second exception? I heard the first one. They drive as part of their job.
It's actually a two-part exception. So both if the driving's part of their jobs and if there would not be an additional burden in terms of time or cost to the employer. So for example, if the job is to make deliveries and that's your full job, driver's license is okay. If your job is a bookkeeper, you're gonna drop off checks once a week at a bank, public transportation is probably not gonna add, or taxis, probably not gonna add too much more cost and expense for the employer. Yep. California has a lot of protections for employees, not too many for contractors. SB 988 is a new law that provides more protections for contractors, but it's not too onerous. The gist of the law is that for hiring entities, when they engage a contractor for certain professional services, they have to have a written agreement that includes certain terms. You can find them all in the statute. There's nothing, everything's in the ordinary: price, timing of payments, etc. They have to provide that to the contractor and retain it for 4 years. AB 2299 made the DIR, the Department of Industrial Relations, post a new whistleblower notice, which is helpful because under the old rules, employers were required to post employees' whistleblower protections, but there wasn't much guidance as to what that needed to entail. Now employers can use the model notice, and if they use that notice, then they will be deemed to have complied with their posting requirements. SB 399 is the captive audience ban that's actually currently being challenged in the court systems. And what the statute does is it prohibits discipline if an employee declines to attend an employer-sponsored meeting in which they communicate their views on political or religious matters. And importantly, their views on union efforts is deemed to be a political matter. There are a lot of exceptions and exemptions for certain organizations, a lot of nonprofits, religious organizations, political organizations, and the like. And last but not least, we have AB 2123 that prohibits employers from requiring that employees use vacation before they receive paid family leave benefits. So paid family leave is a state-sponsored benefits program where if an employee is absent to bond with a child or to care with the family member, the state provides certain benefits. Before AB 2123, employers could require that the employee use 2 weeks of vacation, not anymore. So a lot of handbook language about paid family leave benefits might be outdated. And of course, administrators of any such policy should be trained on the new law. And with that, turning it over to Kevin to talk about PAGA.
All right, your favorite thing, wage and hour laws. Well, I could give you this sort of 15-page summary about all the different updates, but I assume you do not want those at this moment, especially since there are a lot of legal intricacies. And I saw a survey that I think over half of you today are HR professionals. So I'll keep this a little more HR specific. So I like to start with good news before I get to the not so good news or bad news. So the good news is that PAGA was reformed. I would say it was not, and PAGA is the Private Attorney General Act. And this is basically the vehicle often that the plaintiff's bar uses when they want to bring a wage and hour class action against on behalf of all of your non-exempt employees in your organization. And there were a lot of different ways in which plaintiffs' counsel brought interesting theories to sort of propound additional penalties and really make these a cash cow. And so there was a lot of discussion in the legislature and how to make it a little bit more fair for employers. And especially since I think employers really started to threaten that they were going to bring a bunch of referendums. So the California legislature sort of came up with this compromise. And a quick highlight on the good news part of it is a lot of those penalties I was talking about are no longer going to be compounded. And one of them, there were a lot of ways in which the plaintiff's counsel could sort of double dip in penalties. Like if you missed a payment, for example, on a meal break, that would show up on the wage statement, and then that would show up in a wait time penalty, and you would get penalties on top of that. And so basically you're getting to one minor infraction that might have been you owed an employee $15 to now you owe for that one violation thousands and thousands of dollars that compounds into millions. So the good news is that has been reduced and clarified. There are also a lot of mechanisms now employers can do when they receive what's called a PAGA letter to cure some of the deficits to potentially lower the amount of penalties. And then if you are hit with a PAGA claim, there's some clarification through the civil procedure. There's some a motion that's been codified where you can sort of limit or cabin certain types of claims so that it's not as unwieldy when you're defending it. And it also clarified that these PAGA penalties are only 1 year. Some plaintiffs' counsel were trying to get real creative, arguing what's called the continuing violations doctrine to try to get more and more penalties. And then the last takeaway is for the good news is there was a recent California Supreme Court case that clarified that you're not subject to some of those penalties as an employer if you can show that in good faith you tried to comply with the law, which generally looks like you had policies in place that were compliant with contemporaneous law, which then comes to the not so good news, which is the next slide, which is basically we're going to get into none of the actual labor code violations changed. So from an HR and in-house counsel perspective, you have all the same strict requirements that California has. And as we will say on the defense side, almost no employer is 100% compliant because it is virtually impossible to do so, especially if you're at a bigger size. So all we can do is, and help you do that, is mitigate the possibility that plaintiff's counsel is going to bring a wage and hour class action. So I will say another thing that's not great about the reform is what we're seeing, and some of the mediators are talking about this who handle settlements of these types of claims, is that the plaintiff's bar, now that it's not as lucrative, when they find a good case or they find that there's a violation that can stick and that they can get a class certified, they're going to hold on to it a lot tighter. And they're going to expect a bigger payout because they're not going to bring as large of a volume of cases as they previously have been. Which means, which is the HR part we should focus on, is let's talk about a few areas that are hot topics, especially in recent court decisions where plaintiffs' counsel really like to go after, that you can really shore up and have a few takeaways and homework to do if your current company is doing this. And I should also note for any of you national employers here, you really have to think critically about how California is different in a lot of ways than the Federal Labor Standards Act. There's a lot of key differences and you need to make sure that you're doing everything properly. So one of the biggest areas that we've recently seen all ties into timekeeping for non-exempt hourly employees, and whether or not we'll talk about this neutral rounding policy. It's a really hot topic. So first off, in California, there is a key distinction in one of the employer defenses, which is that this de minimis defense. And what that means is that there used to be this defense, or possibly in California, but you can argue this federally, that if it's only a few minutes here and there that you're missing and didn't pay out your employees, you weren't necessarily liable for it. Well, in California, in the past couple of years, there's this big case that came down against Starbucks that said, no, California doesn't allow that defense. If you owe those 2 minutes, you need to pay them out. And like we talked about, that propounds into a bunch of other penalties. So you really need to shore up on your timekeeping and make sure that your policies and procedures are compliant, that you are making employees write down and record every single minute that they are working and that you are paying that out on time. A few big examples that have come out talking about COVID, if you have like a warehouse or something like that, there were a lot of COVID-19 screenings, like temperature checks and stuff. And there were a lot of cases about whether or not the employees should be paid for that time waiting through the temperature check system and stuff like that. Make sure that you are paying, it's safer to pay employees for that time. And so then let's get to rounding. That's one of the biggest areas. It's about to go up to California Supreme Court, but one of the Court of Appeal came down against Home Depot and said basically that in California, you cannot have a neutral time rounding policy. What a neutral time rounding policy is, which is allowed federally, is let's say your timekeeping system, for whatever reason, between your payroll, it's too hard to pay out every minute. And so what a lot of companies were doing with their timekeeping vendor is they were rounding to the nearest 15 minutes, meaning let's say you worked 5 minutes over the hour, if it's less than sort of 15 minutes, or it's not as close, it's closer to 0 minutes, than 15 minutes, which means that you would not pay for those 5 minutes. But the assumption would be that because it's a neutral policy, you would net out to about the correct amount. Well, the California Court of Appeal said, in this day and age, Home Depot, you have the time records, you should be able to pay down to the precise minute you owe that amount. If the plaintiff's counsel can show that it nets out to something that is, where you're owing employees, you owe all those penalties and you owe all those wages. And that is an area in which plaintiff's counsel have really been drilling home and have been filing a lot of cases. The reason why it's super popular is because it's easy to certify the class, because it's a uniform policy and practice, and it's really hard for employers to defend. On top of that, oftentimes, if you're using the same national vendors who were engaging in this time rounding practice, a big thing that's also happened is often that required 30-minute meal break. If an employee, let's say, was exercising about 28 minutes, not the full 30 minutes, and they were coming back on shift a couple minutes early, that time rounding system would say that they completed their 30-minute meal break. Well, per California law and Donahue v. AMN services, that's not okay. In no situation are you allowed to engage in time rounding. So you would owe an hour rate of regular pay for that missed meal break, even though essentially the employee got the full meal break, maybe just a minute or two off. But again, these turn into $1 million cases. What you can do that we would advise is really you need to work with your payroll team, look at your policies, make sure that you do not have a neutral time rounding policy and that you are paying down to the minute. You should also be double checking with your vendor and your systems to make sure that they're accurately recording and paying out for every single minute, that they're properly recording meal breaks, because you'll have a huge problem. I should also note that other states are following California. Oregon, for example, passed legislation that you can't engage in the neutral time rounding policy. So again, for you national employers, you really need to look at different states. And I would look to the most progressive states if you want a more uniform policy. Otherwise, you are going to have a bunch of state addendums if you want to use federal law as your default. And then another area quickly is the cell phone and internet usage for work. This doesn't tend to be the reason why plaintiff's counsel will file the class action, but it's a claim that they'll quickly slap on there, and it's difficult to defend if you're not properly, if you don't have certain policies or you're not paying a stipend for cell phones. So if your work requires, for example, if you're requiring your employees to check their schedule on an app that they download on their phone, and you're not administering like a company issue cell phone, or you're asking them to do things outside of work, not only do you need to pay them potentially for that time, but you need to be providing a stipend or some kind of reimbursement process to pay for that usage. That's a place where plaintiffs' counsel love to tack on to class actions. So that's pretty much it, unless you have any other questions.